The second matter that I wish to address relates to the Commissioner's investigative powers. The CEO mentioned in his appearance how important it is to have timely and effective enforcement of elections laws. It is fair to say that among Canadians, there is an expectation, and I would say an entirely reasonable expectation, that significant violations of the rules governing elections will be dealt with swiftly and within a normal 4-year electoral cycle. When the very legitimacy of elected office is at stake, the need to resolve allegations of electoral wrongdoing is, by definition, a pressing matter. This is why, as I indicated in my annual report, I believe it is essential to give the Commissioner the ability to seek a court order to compel testimony. Selon mon expérience, il n'est pas rare que les gens...
My experience to date has been that it's not uncommon for individuals who are not directly concerned with an investigation, but who may possess important information, to refuse to cooperate. In a political context where partisan loyalties are strong, this should probably not come as a surprise. However, this can cause significant delays or even compromise an investigation. The power to compel testimony in the context of election investigations exists in many provinces and territories, and this includes Quebec, Ontario, New Brunswick, Alberta, Manitoba. Other regulatory agencies also have similar power. The CEO and myself have both recommended this power be given to the Commissioner with a number of appropriate safeguards, as exists in the Competition Act. These safeguards would include the following. In order to obtain a court order, a prior judicial authorization based on affidavit evidence showing that a person likely has information relevant to an investigation of an offence under the Canada Elections Act. Secondly, the right to be assisted by counsel and to have counsel present at the interview be available to all. And thirdly, and most importantly, the individual to be questioned would have the right not to have the evidence used against the individual be used against them.
Balanced approach to ensuring more effective enforcement. And Mr. Chair, I want to be absolutely clear. If this amendment is not made, investigations will continue to take time, and in some cases a lot of time. And importantly, some investigations will simply abort due to our inability to get at the facts. Bill C-23 should also be amended to improve the regime proposed for voter contact calling services. First, whether it is a live or automated call, there should be an obligation to identify the source of the call immediately at the start of the message. Secondly, and most importantly, entities providing automated services or making live calls should be required to preserve a record of the telephone numbers that were contacted and to make that record available to the Commissioner through the CRTC. Without telephone numbers, it is difficult to see how the proposed regime can be of much use. Enfin, en ce qui a trait au pouvoir du commissaire, je suis très préoccupé.
Finally, with respect to the powers of the Commissioner, I want to express my deep concern with the limitations imposed by C-23 on my ability to inform the public of the results of my investigations. There are certainly excellent reasons to preserve the confidentiality of investigations, protection of privacy, etc. But it mainly includes consideration of privacy and fairness, as well as the need to protect the integrity of ongoing investigations. But for this reason, I will generally not comment on or disclose information related to my investigations unless when necessary in the course of the judicial process. There are, however, Mr. Chairman, rare but important exceptions to this. When allegations have been made publicly that may cast a doubt on the integrity of an election and where an investigation shows that these allegations to be unfounded, It's important that for the Commissioner, myself or my successor, to be able to reassure Canadians by making the findings public, including providing certain factual details of what was uncovered. I note that my predecessor had twice used this mechanism in recent years, and it's important that my successors or myself be able to do the same in future. And finally, Mr. Chairman,
I'd like to mention the addition of a number of new offenses and a proposal to increase fines. The increased fines in particular are a significant and welcome improvement to the regime. However, as I indicated in my annual report, achieving compliance with election rules should not rely primarily on criminal offenses and sanctions. The criminal process is inherently slow and heavy-handed. It is ill-suited to the vast majority of instances of non-compliance that we in the Commissioner's office encounter, which are of a purely regulatory nature, for example, late filings of reports. Administrative sanctions, such as the proposed automatic reduction of reimbursement on election expenses in cases of overspending, are generally much better suited to deal with compliance issues related to political financing. In this regard, I hope that this measure in Bill C-23 will point the way for future reforms. En conclusion, je tiens à préciser.
In conclusion, I'd like to indicate that I fully support the amendments related to enforcement that the Chief Electoral Officer suggested at his appearance on Bill C-23 a few weeks ago. I'm also aware of the fact that the Minister of Democratic Reform has written to the committee and that he appears to be open to some amendments dealing with the limitation period as well as the threshold to initiate investigations. And in closing, I would strongly encourage the committee and members of the committee to examine and consider other amendments on enforcement proposed by the Chief Electoral Officer. Mr. Chairman, that concludes my preliminary remarks, and I would be pleased to answer all your questions insofar as they do not relate to the particulars of any investigation that is currently underway. Thank you.